Court calls the case People versus Rosemary Harrell. That all of mine.
Can you take my signature?
Yes, sir.
Assistant Public Defender Hannah Apple appearing on behalf of Rosemary Harrell.
You're requesting competency forensic evaluation.
Correct, Your Honor. And then if we could approach.
Pardon?
If we could approach briefly.
Forensic evaluation is hereby ordered. I'll set a competency hearing for 90. June 6th. June 6th. June 6th, 2024, 9 a.m. Council approach. All right, we're back on the record on this matter after a bench conference. At this time, bond will continue. And as to what we discussed, Council, you can let me know. Thank you. All right. Court calls the case People versus Benny DeNovi.
Drink is the devil.
Good morning, Your Honor.
Right. The singer?
Won't let me start the video for some reason.
Okay.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Genovi.
Is that true?
And I'm Special Assistant Attorney General Mitchell Wood for the people. I don't know that we have a case number, Judge.
Good morning, Your Honor. Eric Julian appearing on behalf of Austin Bryan, who is present. Can you state your name, please?
Austin Bryan? In all four cases.
Yes, Your Honor, in all four cases, and I do have a preliminary exam waiver in all four cases. Oh, I'm sorry.
On all four?
Yes, Your Honor. I did write all four case numbers on it.
All right. Sir, you're waiving your right to have a preliminary examination in all of these matters?
Yes, Your Honor.
All right, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you won't have that hearing and that any of these hearings, and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right in these matters. Preliminary examination having been waived, defendant is bound over to circuit court on all counts with any misdemeanors following.
Yes, Your Honor. We would acknowledge receipt of the information. He was formal reading and stands mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pre-trial in these matters will be set for
March 19th at 1:30 before Judge Punky.
March 19, 2024, 1:30. Bond will continue.
Thank you very much, Your Honor.
Thank you. And good. I've got, who do I have? There. I don't have a file.
There you go.
Court calls the case People versus Patrick Connolly. Two cases.
Attorney Morgan Barossa on behalf of the people. No counsel that we appointed.
All right. Sir, your name?
Patrick Conley, sir.
Okay. You went through an arraignment on these?
Not quite sure. I think I'm here for a bond arraignment.
Are these set for arraignment?
I'm not real sure.
Hold on.
I think it was for a bond arraignment.
For the fresh hour and what?
Last week.
Good day, Mr. Brown. How are you?
Okay, and so what happened with?
I was there.
That's why my files are messed up. Okay. No.
So I represented him with some misdemeanors, and then prosecutor dismissed the misdemeanors, filed felonies against him. And then he was supposed to, this was on Tuesday last week, but Thursday, he didn't make the cut for the PCC. So I guess he's here for arraignment on the new felonies. Like,
Well, hold on a second now, because you have
It was already arraigned. Given conditions.
Okay. I don't know.
Should be, yeah, he was already arraigned because he got.
He was already arraigned on these. However, what we don't have is they don't have counsel appointed, but your understanding, Mr. Brown, was that the PD was handling these
Well,
or, pardon?
I can.
Well, you want counsel, sir?
I would like to know why I'm here for one. I thought I was I spoke
Okay.
to a lawyer last week. They were set up a bond hearing for me for.
Let me
Yes, sir.
Let me stop you real quick. When you say you spoke with a lawyer, do you know who that was? Was it somebody from the public defender's office?
Yes, sir, it was.
Okay,
It was a young lady.
okay, that
And-
narrows
and I
it down
think
to
with
about
Miss-
30,
Yeah.
but go ahead.
With Judge Fink, they were set up a bond reduction hearing of sorts. I thought that was why I was coming in. For today, I'm not, and maybe get released.
So hold on, were you before Magistrate Fink or before Judge Freshour?
I was before Magistrate Fink, but I was arrested, I was detained
Okay.
through Miss, who you said, the young lady from Saline. The judge from Saline, I can't pronounce it, I'm sorry.
I'll tell Chief Judge Freshour. you
But I
told her
was,
that.
I was detained then, but I had went and spoke to a public defendant from your office about a reduction in.
I don't have any
bond.
public defenders in my
Yeah,
office because I don't let them in. Okay, I'm trying to figure out, sir, there were misdemeanor cases
Yes, sir.
that you had out in Saline
Yes, sir.
at some point,
Yes, sir.
correct? My understanding from what Mr. Brown just said is those were dismissed.
And yep,
And then what my file looks like is that you were arraigned then on new felony charge
yes, sir, correct.
at that time.
Yes, sir.
All right. And at that time, you were, I'm presuming at the arraignment, you were apprised of what the charges were against you.
Yes, sir.
Okay. So what I have, so that you understand, is I have one case that is noted, actually both are noted as a reauthorization. I have, in one case, that being case 0274, operating with a high BAC third offense and driving while license suspended second or subsequent offense.
I had no.
So hold on. So that you're clear, that offense date is May 29th of 2020. Okay, that's one case. The other case that I have is operating with a high BAC third offense also, and then driving while license suspended, denied and or revoked second or subsequent offense, as well as, I think I've got one more charge on that one. I got, okay, and then also on that one, a misdemeanor charge of operating a motor vehicle without security, and another misdemeanor charge of operating an unregistered vehicle. That's on the case that ends in 0273. Okay, that offense date is September 24th of 2022. Okay, you were apprised that that's what you're being charged with, sir?
I suppose I wasn't aware of the suspended. There was no added charges to any of the other offenses, the two blood alcohol offenses. I wasn't aware of any additional charges on that other than just the high blood alcohol.
Okay, so just so that you're clear, there are two high BAC third offenses, two felony charges.
Yes.
Okay, with different offense dates. So there are two
Yes,
of
sir.
those.
Yep.
There are two charges on those same dates of driving while license suspended second or subsequent offense. Okay, that's a 1 year misdemeanor.
Yes, sir.
Okay, And then on the newer case, the one occurring in 2022, you have operating without security, basically operating a vehicle without insurance.
Yes, sir.
And then operating an unregistered vehicle. Both of those are misdemeanor charges.
Yes, sir.
Okay, are you clear on what you're charged with?
Yes, sir.
Okay. Now, because I have you as having been arraigned and that you were not given, I don't have counsel appoint or set for you. So my first question to you, now understanding the charges, do you wish to be represented by an attorney?
Yes.
Okay, these are public defender cases.
Thank you, Your Honor. Lauren Brown, the other Mr. Brown, the less handsome one, appearing on.
That is so true. But go ahead.
Your Honor, what we're going to ask for is a 2-week adjournment, then be asked to be allowed to address bond.
Okay. So I'll adjourn this out 2 weeks, but before you get to your bond argument on it, so this will be adjourned to March 21st, 2024,
Yeah, they're at
9 a.m.
$50,000.
10%.
So now at some point, and now this gets to what Mr. Connolly was, I think, talking about. At some point then, after you saw Judge Freshour,
Yes, sir.
you then saw Magistrate Fink. Is that right?
Yes, sir.
Okay, at some point, and I'm just going by what you're saying because I don't see an indication in the file, but I'm trying to figure this out as we're going through it. You believe that you were here for a bond?
Yes, I believe the young lady's first name was Natalie.
Oh,
He actually has a DV case with Judge Freshour.
And that's on the,
Violation hearing on the 14th.
oh.
and that's Friday. Next week.
So but the whole bond thing wasn't on these cases. It's on another case.
I'm not even real sure.
Okay, so
Because-
he has a bond hearing on that one on,
March 14th with Judge Freshour.
okay. So you do have a bond hearing. You probably did see the magistrate regarding that bond hearing. That is a separate misdemeanor case, which you'll be heard before Judge Freshour, according to my staff, on the 14th.
Okay.
Okay?
I think I have something on the 12th as well.
Wow.
That's they threw
Where?
it at me at one time. Like
No, that's okay. I'm just trying to figure out
I thought the domestic one was
that's on the 14th.
Yeah.
We figured that out.
I had something that was arraigned over from a rainy day we had freezing rain and the court was canceled. They pushed it to the 12th.
Do you know?
But
No, it's okay.
Yeah.
Well,
I'm still trying to make sense.
because we had, the 12th was also exam date. So was he set for an exam and that got pushed over?
Your Honor, if I may,
Please.
the only 3 cases he has right now are the 2 that are up for today and the DV that he has in front of Judge Freshour. The DV he has in front of Judge Freshour, he has a $1,000 10% bond in that case because he failed to appear. That is up again on March 13th. The 2 cases in front of you today are reauthorizations of cases that were previously charged as misdemeanors. They were reauthorized by APA McDuffie because he has had multiple community correction violations before completely absconding in 2022 and early in 2023. My understanding is that in charging those misdemeanors, the charging APA missed the prior offenses, which would have brought this into the felony level. So due to the combination of the circumstances, due to his absconding and community corrections violations, as well as discovering the missed priors, they were reauthorized as felonies. I do also know that Your Honor does is not overseeing the DV misdemeanor in 1484, but if the court could remind him that he is not supposed to have contact with the victim in that case, that would be greatly appreciated, because there has been jail calls there as well.
Okay. All right. So you said his DV is on the 13th before Judge Fresher. 14th in 4, and that's what we just told him, I think. Okay.
There's nothing on the 12th.
There's nothing on the 12th that we see.
Okay,
Got that?
yes, sir.
Okay. So you wanted to address bond. Sir, well, let me just say this. That's not my case. It's Judge Freshour's case, but I'm sure as a condition of the DV case, you're not to have contact with the alleged victim in that
Yes, sir.
case. That means you cannot make those calls if there are calls being made from the jail.
Absolutely, sir.
You understand
Yes,
that?
sir.
That contact is either directly or indirectly.
Yep.
You can't have somebody call on your behalf or anything along those lines.
Yes, sir. Yeah.
Understood?
Yes, sir.
All right, thank you.
If I could make a note to the court about that. No,
Well, you probably
Never
don't
mind, I'll
want to,
speak to
because
him.
if I have to go grab the file, things are gonna get
no, sir.
bad.
That's
All right. Mr. Brown,
So the bonds currently set in the 2 high blood alcohols are 10,000 notes.
what do
My
you,
understanding is that in each file up today, it is 10,000, 10%, so
Or 10%.
I do believe that we requested 50,000 unsecured appearance bond. I do believe that bond is appropriate. Cash surety.
10,000 cash surety on both?
Yes.
Okay.
Oh, Your Honor, the bond set at 10,000 cash surety, my client is unable to post that at this time. He,
if it's 10%.
he has an address at 167 in Saline, Michigan, to which if he were to make bond, be able to go to that address. He was in the course, he had 2 job interviews when these cases came up. He'd like to get that back on track so that he can become employed and become a contributing citizen. If, in fact, there will be a necessity for some sort of alcohol treatment, something moving forward, he would be in a position to pay for those things. He's asking for a PR in this case. He's asking that the court allow him 10% privilege. Will return to all future court dates. He will follow the strictures of the court.
Okay, well. If I make a couple of my mother.
So, Your Honor, also he would ask that if the court would consider SoberLink, that would be a good way of keeping track of him, sure that he is following at least the notion that he not have alcohol while he's out.
Okay, 2 things that I'm concerned about is, one, there was an indication that he didn't comply with the directions of community correction previously. I don't know much about that, but that was brought up. And while the word absconded was used, there, it seems to me, a period in time which he didn't bring himself before the court. Ms. Barroso.
That is correct. My notes from Ms. McDuffie indicate that when this case was reauthorized, the defendant was in bond violation and in bench warrant status. According to Ms. McDuffie, the community corrections violations include 5 positive tests for cocaine before he completely absconded, missing 7 tests between December 2022 and January of 2023. My understanding is that his license has been revoked for at least the last 20 years. And has, like I said, he has a history of failing to appear. So I'm very concerned. I also do want to note that the data master results from at least one, or from one of the, I don't have them on the case number ending in 0273, but in The 0274 file was a 0.2 and a 0.19, so I don't think that a sober link would necessarily be sufficient in this case. If the court was inclined to modify bond, I would be asking at least for a scram tether.
I'd be willing to do that.
He'd be willing to do that, Your Honor.
Sure you would. I think the difficulty, the concern that I'm having, I think we can figure out the alcohol component of it. I'm worried about the cocaine usage, which I can't monitor from afar with a sober link or a tether. He would have to appear at community corrections, but then that goes into the issue of him disappearing and not bringing himself before the court, which also causes the court a bit of a problem.
I think. So. I think twice a week to test. That's a.
Is there anything else, Mr. Brown? I know you.
He would be willing to come into community corrections and test twice a week, Your Honor.
Well, he did that the last time, my understanding was positive, and then poof, we didn't see him. So here's what I'll do at this juncture and allow everybody to get all of their information straight with them. I'm going to continue to defendant's bond as is right now. I don't have a problem either by written motion or otherwise addressing it then on the 21st, when everybody has everything that they can place in front of me, one way or another. So at this point, bond will continue. Thank you.
Thank you.
So.
I don't know what they did because there's a note that they moved that. I don't know what they did.
Who is present with me, Your Honor?
Your name, sir?
Terrell Daniels.
Thank you.
Your Honor, we are requesting a preliminary examination in this case.
Discovery complete.
I believe it is, yes.
People have their witnesses available on the 19th.
I believe so, Your Honor.
Preliminary examination in person, March 19th, 2024, 9 a.m. before Judge Perry. Bond will continue. Yeah.
I wanted to ask the court to remind the defendant that he's not to have
Don't say
contact with the
anything.
victim. He called her twice, and it's understanding he hasn't talked about that with counsel yet. So we wanted the court to remind him he's not to have contact with her.
So he's contacted the victim twice.
Yes, Your Honor.
You know,
No, Your Honor, I was just informed about that by Ms. Barroso today. I'm not certain of the content of those. I respectfully ask that at the most, for purposes of today, you admonish him, or certainly.
actually,
Now,
here's
please
what we're gonna do.
remind-
He's got an exam coming up on the 19th. I'm revoking his privileges. You can bring it up before Judge Perry. To get him back. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Bernard Brock.
Andrew Banis, Assistant Public Defender, with on behalf of Mr. Brock, who is present.
Your name, sir? Bernard Brock. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
All right, the plea form indicates that the defendant will be pleading guilty to an added count 2 of larceny, 200 to 1,000 to 1 year offense. Upon a successful plea to that charge, count 1 would be dismissed. There also is indicated there is no objection to HIDA.
That is our understanding, and I have discussed that with my client a few times, and also this morning, and I believe he wished to proceed.
Yes. Is that? Thank you. May I have him sworn, please?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Bernard Brock. All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of larceny 200 to 1,000. Is that correct?
Yes.
That is a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. the fine could be increased to 3 times the value of the property, which is the subject matter of the theft or larceny. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court. You understand that?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
This is what we reviewed earlier today.
I'm aware.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
On December 13, 2021, at the location of 6405 Jackson Road, Scioto Township, Washtenaw County, State of Michigan, what'd you do that makes you think that you're guilty of this offense?
So basically, I purchased goods with intentions of not to giving it back.
Yeah. Would you like me to voir dire or no?
Please, because that didn't make that a
Did you-
crime.
Did you, and that location was a Menard store, right?
Yes.
That
correct.
was open to the public at the time.
Yes.
And did you take lumber without paying for it and without the owner's consent?
Yes.
And at some point that lumber was moved, there was some movement of it, right, into a U-Haul truck?
Yes.
I'm going to the larceny. And at the time you took that property, you did not intend to give it back to the owner, correct?
Yes, correct.
You
So
have,
you took lumber from Menards, right? And you moved it off of the property?
I didn't move it off the property.
So in some way you concealed it from the owner
Yes.
in the U-Haul?
Yes.
Is that correct?
Correct.
And you didn't intend to pay for that property, correct?
No.
Okay, you intended to take it away from there, right?
Yes.
All right, but was the value of that property in excess of $200?
you know, well, my advice is based on the discovery, yes, it was, and we would stipulate to that.
You'd stipulate to its value being in excess of $200?
Yes, Your Honor.
The misdemeanor that was offered in place of the felony is larceny of property of a value at least 200.
2,000.
2,000, yeah.
Yes.
And do you agree
So
that?
are you stipulating to the 200?
Yes. Yes.
Yes.
Honor.
All right, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be
April 1st at 9 a.m. before Judge Freshour.
April 1st, 2024, 9 a.m. before Judge Freshour. Bond will continue. Thank you.
Thank you. Send you that in.
Court does call the case of the people versus Deja Foster.
Ron Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Foster. State your name.
Deja Foster.
Thank you.
Your Honor, we are still scheduled for a competency review hearing. We have not.
I have no report either at this point.
Well, Your Honor, we ask for a 3-week adjournment. Hopefully the report will be complete.
All right, what I'm trying to do with these, because of the delays that are happening, I try to put them out about 30 days and then we'll move it up if we have to. So,
April 4th.
or
Yes.
So I'll adjourn comp review hearing to April 4th, 2024, 9 a.m. Bond will continue.
Thank you.
Thank you. Court calls case People versus Dominic Hemingway.